Audio Jungle.
Alright, Ebusia, aha, Ayebu TV. Make sure say over like over commenting now, watching videos ni edi amamna. Gana for Abamonte so just say Abronye DC beje wubo isan say okan. Yeni tia ye maame sina tamakulu chese nansi yenya nti yese yemfane enkotu efiase na court ho nsensem eba emonte so na chese attorney general Monte so ebe catch a court of appeal say ebe ya enka judgment no omo suspending no kaka ebusi asem we na akofa ensem bebre aba na ebusi amintumi enchire ensem ni mu ema wonya ensem ne enti ase bebre intinti me sure so be come on ye yabo era ensem ne akotie ensem ne se de ne fari ban esete ne bi emba
by the Appellate Court. Section 31 of the Court Act. Check 31(2). Now, the Parliament in Maxwell, said the Court of Appeal, as any appellate court, will be on the ground say charge sheet defective, provided say. Miscarriage of justice, MIA, and so evidence via any record, Nipano, before. So the Court of Appeal is faulted firstly by Section 31.
And it's your considered opinion, sir, when they establish a charge sheet defective, no? What should have been the decision, sir? They order a trial de novo? And answer
I'm coming there.
Okay.
I'm coming there.
Okay, that's fine.
So the first time I say that's very defective, no? Next phase, and say, she say, a dance here, a warm crack, no? A dance here, a support to any other time, charge, as you have it now. And I am pushing your catcher, and say, could work as a charge a defective one. What you do, say you order trial de novo.
It should be for.
Exactly. Because Ebasana is on technical ground.
Yes.
So because we are talking about 90 million Ghana cedis. And I can't want it. But I would say, cash sheet, defective. So that's the first point.
Okay.
Second point, now a dance here, court anymore, court to be any fast one, and a dance here one could be so, like I said, judgment, like I said, amen. Kind. 500,000 Ghana cedis, I can't say, Maslow for the command, that institution, Ashanti region, no. A dance here, the court, and they say, a microfinance company in Sakas, the cano. Who said interest was no moon to be here. Don't be some more the check. Ebra Maslow, my mate Temakulu, now send it to be out for 3 years. Mamma said, Debbie, on a board chairman, look, I said, Debbie, me cash. I dance in American to be what dancing. Yes, I cash no bank, that institution is kind of cash at the bar and kind. But you'll be here, mamma, no more. There's a filling station, Barcelona, filling station. There are dancing,
okay.
And on this cano, a sharing said. Then I'll choke that and a sackers cano. But the sackers cano will find commerce lock accounts to be. It's a great dancing. Yeah, judgment and I can say, I still say a dance here anyhow. So that's the first a dance here. Solid. Unless say, could appear a patch and say, I can't dance here, my Jesus Christ. If I am a quarter any dance here. Solid a dance here. Number 2, a dance here, I won't crack as well, she said. Mammy Tamaklu, and Mra, a jar a shake and tamanto. Omampani Mahama Samre 2013-2014. Because on money first time Maslow for, na says cano, Umfankoma, get the 4 mano, and show me Omujum. That's kind of similar wrong at almost 1.4 million Ghana cedis. Audits now, yeah, it shows say, can be a core man or no, close to 700,000+ Ghana cedis. Almost 600,000 or 700,000 there, can anchor money be out. And yeah, dance here. Report no at that court farm also. Number 3, Maslow, yes, almost sensitization program from a man, almost discussed from about 80,000 of them throughout the 10 regions. Then 10 regions are organized, and on budget close to 1.8 million Ghana cedis. Mami Tamaklu, eco region me and sape out of the 10. Yes, so called yes, score spending a pay within 1,300, meaning I nearly 13,000. 1,003. So meaning almost 1.7 plus million Ghana cedis, and also of fire. Another one. We are financially literacy for almost clients maybe. In terms of 246,000 Ghana cedis. 1 year when you spend even 1 cedi out of the amount, 1 year program na nipa ni bia. That's can pass and come back. Do you dance we a walk in Kratemu? And the last one, almost talk has be 350. Yeah, the dance by the Kana Canebo in a coastal panel, $10.something million. Now, so we have $14.5 million. Yeah, a dance any Sunday my Nina. Now, the same Mama say, I dance the bay more do Nano, Mamma no, United say, oh, my court, I mean, and say, I deal with you, and you know, in it here. So, on what basis would the court of appeal say, a dance here in this assembly? Again, I'm going to make also obedient that can so when I know correct, Mr. Scanner by the Koha, the winning Koha, then that case all two sides. Minister criminal prosecution, the state must prove his case beyond reasonable doubt. But on the side of the prosecution, I mean, I can tell you without any equivocation, the said the state prosecutors are only a Juma way, no, only a Juma pa. This tells me the man we the public servants on Juma investigators are more yoku. The kind of Juma Muye or Sadia we move, auditors a Juma Muye, don't be a dance or court. The other court to Ghana, like Court of Pika say, a dance anywhere. Like I say, a idea, maybe 2 months. But
lawyer, even before Sawubeba, whether the charge sheet was defective and actually defective, no, on even the evidence, no, and the probative value according to evidence, no. The Court of Appeal in Omu conclusion page 92, 93, and 94. Mintimin kind, and I'm only taking a cursory look. So I share conclusion almost say paragraph 120. It has long been the golden thread running through our criminal jurisprudence that the prosecution must prove the guilt of the accused and that this burden never shifts unless the enabling statute or law has expressly and clearly said otherwise. The principle articulated by Viscount Stanky in Wilmington versus DPP, our law student, and unshaken sins is not a technical nicety of procedure. It is the constitutional expression of the presumption of innocence, and it is owed to every accused. 121, I'm going to say, the learned trial judge lost sight of this. Confronted with a charge sheet drawn mostly in negative terms, that the appellant had acted without authorization or without due process, she reasoned that because the prosecution had averred a negative, it fell to the appellant to prove the positive. That authorization, process, or justification in fact existed. With respect, that reasoning inverts the very principle it purports to apply. 122. The manner in which a prosecutor chooses to draft a particular offense cannot, of itself, relocate the burden of proving an ingredient of the crime. A negative averment, artfully or carelessly pleaded, is not an exception or proviso. It's not an exception, a proviso, or a statutory defense. It remains in substance an element the prosecution must establish, and the difficulty of proving a negative is the prosecution's difficulty to bear, not the accused to solve. I will go further to emphasize the principle that unless a statute plainly places the burden of proving a particular element of an offense upon the accused, she is under no obligation whatsoever to lead evidence in aid of a prosecution's case that has not yet reached the threshold the law demands of it. To require otherwise is to ask the accused to complete the prosecution's unfinished work and to convict her for declining the invitation as was done by the learned trial judge. The prosecution's evidence on a fair and unaided reading fell short of proof beyond reasonable doubt. The shortfall was not made good by any burden properly resting on the appellant, and the trial judge's misdirection on this fundamental point goes to the very root of a fair trial. For these reasons, therefore, I am satisfied that the conviction and sentencing on all the charges, including those manifestly defective charges, cannot stand. I would allow the appeal and set aside the appellant's conviction and sentencing on all count. In the way and Justice Emmanuel Ankama, I'm not sure this lead opinion, the conclusion, one, the evidence he believes say you couldn't prove the case beyond reasonable doubt because that it was for you to prove and not for the appellant, to rather prove positive. When you crafted the charge sheet in the negative. Okay, counsel.
What kind the judge misapprehended, misunderstood the import of the prosecution's case. With a great respect to the judge, his appreciation of the burden of proof, wrong. In criminal cases, the state or the prosecution is supposed to criminal cases. They'll say, there are some courts, it seems to be a case beyond reasonable doubt.
Yes.
Everybody knows. This is not something the judge should lecture anyone.
Yes.
Now, who we are, then the accused person will have to just raise doubt to show, say, the okay, no proof beyond reasonable doubt. Something that everybody knows. So, before what to me, it does not answer the question. The key question is, charge sheets that the state prepare, you must get evidence to back the charge sheet that was required. The advance year a was a state no the advance and by my minus cratana of sign say scan magic cash a free more. Nipo discabay no back case or baby shan bachona filling station and can manage it canon. Accounts on prepare and issue say one first can go to company with the accounts no. If the get up a before Kaina ministers come manager no Rofun Kataswana. No, that is not how the law works. With all due respect, the trial judge, a very good analysis of the judgments. I mean, you call the judgment and the first one judgment now. To the extent say, or evaluate the evidence, no. My question is, lawyer, no, you can consider it.